If you apply for expungement in Florida the wrong way, you're not just risking denial. You could actually lose your chance to clear your record altogether. And most people don't even realize that they made a mistake until it's already too late. Hi, I'm Mo from Erase the Case, Florida's expert expungement law firm. In this video, we're going to walk through the #1 mistake that gets expungement applications denied here in Florida. And more importantly, how you can avoid putting yourself in that position in the first place. The biggest mistake we see people making is applying for expungement when they're not actually eligible under Florida law. Now, on the surface, that might sound obvious, but in reality, it's where most people get tripped up because the rules around Florida expungement are very specific. And a lot of the information that people rely on is either incomplete or just misunderstood. So what ends up happening is they think they qualify when they actually don't. For example, a lot of people assume that if their case was dismissed, that automatically means they can get expunged. But that's not always true, depending on the full history of the case. Other people think that because they didn't go to jail or because they completed probation, that they should qualify automatically. But those factors actually don't determine the eligibility the way most people think they do. And this is exactly where the confusion starts to build up. When it comes to expungement in Florida, what really matters are a few key legal details. How your case was officially resolved, if you were ever convicted of any offense, if you received a withhold of adjudication, whether you've sealed or expunged a record in the past, and whether your specific charge is even eligible under Florida law in the first place. And the reality is, missing just one of these details can make you ineligible. What often happens in these cases is someone does a quick search online, maybe watches a general video or hears advice from someone they know, and based on that, they assume they qualify and go ahead and apply. They'll submit fingerprints, pay the fee, and file for a certificate of eligibility, all the while thinking they're on the right track. But then weeks or even months later, they get a denial. And by that point, the damage has already been done. And this isn't just a small setback either, because applying the wrong way doesn't just cost you time, but it can also limit your ability to fix things later on, depending on your specific situation. On top of that, you've now spent money, lost valuable time, and your record is still showing up on background checks for jobs, housing, and other opportunities. A very common example of this is someone who had an adjudication withheld and assumes they can go straight into expungement, when in reality, many of those cases need to be sealed first, before expungement is even an option. So they apply for expungement, get denied, and now they're stuck in a position that could have been avoided if they had just taken the right steps from the beginning. And if you're not completely sure about any of those details, it's not something that you want to take a guess on. Take the time to review your case documents carefully, or talk to someone who understands the process, ideally a professional, because it is always easier to get it right the first time than have to deal with denial after the fact. If you want to find out whether your Florida record actually qualifies for expungement or sealing, go to erasethecase.com and click the Do I Qualify button. And in just 2 minutes, we'll certify your eligibility and provide you a personalized quote if you qualify.